Hello, my name is Gabriele Mohsler. I'm actually the Vice President of Patent Development within Ericsson, and I'm happy to be here today and share with you some of my thoughts. And you're listening to IP Fridays.
Hello, and welcome to this episode of IP Fridays. Our names are Ken Suzanne and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
Welcome to episode 138 of IP Fridays. My co-host Ken Suzanne and I are attending the 2023 INTA annual meeting in Singapore in May. So if you want to meet us in person, feel free to reach out to us and get a meeting set up with us. Today's interview guest is Gabriele Mohsler of Ericsson, and we talk about a large variety of topics such as the UPC, patent quality, standard essential patents, and patenting artificial intelligence. But before we jump into the interview, I have news for you. Germany has ratified the UPC agreement, the agreement of the Unified Patent Court. So that means the Patent Court will open its doors on 1st of June. And that also means that the sunrise period for opting out European patents starts on 1st of March 2023. Also, the German Patent and Trademark Office has a new president. Eva Schewjur has taken over the lead. Before that, she was responsible for the German Patent and Trademark Office and the European Patent Office and the Federal Patent Court on the side of our government, working for the Ministry of Justice in Germany. Now, let's jump into the interview with Gabriele Mohsler. Today's interview guest is Gabi Mohsler. If you don't know Gabi Mohsler, she is currently serving as VP Patent Development at Ericsson and has been with Ericsson since over 26 years and holds a degree of RWTH Aachen in Electrical, Electronic and Communications Engineering. Thank you for being on the show.
Happy to be here. Thank you for inviting me.
And together with Siemens and other industry partners, you have signed the Industry Patent Quality Charter. Just after the EPO had published their Patent Quality Charter, probably not a coincidence, the similar name. How do the two charters differ, and what is your goal for Ericsson signing this charter?
Okay, the Patent Quality Charter, which we see from the EPO, and the one, our Industry Quality Charter, they go well along. But what the European Patent Office is putting down in the Quality Charter is, in our view, more the operational things, getting patents granted in a short time, having a fast procedure, and so on. What the Industry Quality Charter, which Ericsson signed, is about is that we get valid patents, useful patents at the end, so that we have patentable subject matter, which there's no prior art, that it's exactly checked on the prior art, that we have patents that are enforceable. And I would say here, with all the respect, and we are happy to see what the EPO does on the speed and on the internal processes on this. This is one thing. But what the industry, the filers, the patent applicants need to do is more to see that the quality of the end product, the granted patent, is there. And I think there we have a little bit different views, and this is what we are trying to align. And I'm happy to share with you that the EPO now reached out to us and is planning a meeting together with us. It might happen in the beginning of February, and we hope that we are able to share and convince also the European Patent Office what quality means to us versus what quality means to them. I think we need to get this getting together because it's a basis for these companies signing. And there is, I think, around 14, 15 companies currently signing. There's some more that are reaching out to us, and we hope that we even get more companies. What we are talking here is quality over quantity. Quantity, everybody can file hundreds and thousands of patents. That's not everybody, but you could surely do it. But what is quality? So I think myself, Ericsson owns 60,000 granted patents. I promise you, I could have 80,000 in a year if I want to, but that's not what we are aiming for. We are aiming for having quality patents in it. And we have to admit that even in our portfolio, you would find patents which maybe are not valid. That is possible in all of them, but the threshold has to be high, the number of granted patents that are valid and uphold any potential litigation, that has to be high. And this is what we are in our quality charter aiming for. And that's why we were very happy when we saw that Siemens started the initiative, and we were one of the first ones signing, and we are in the core team of going for this.
Yes, from the outcomes of oppositions at the EPO, you can easily see that about a third of all attacked patents are revoked. So probably there's room for improving the quality of the granting procedure, although I also agree that the EPO does a very good job compared to other patent offices with the granting procedure and with the search and but I wanted to ask you what patent quality means for you. Do you have any measurements? Do you quantify patent quality? And if so, what would be the metrics that you use to assess patent quality at Ericsson?
For us, patent quality really is that we have a well-searched and well-examined patent that finds all the prior art around, and that on top has a very good examination procedure by the patent offices, so that the examiners getting the search reports looks into, is it really patentable? Is there any prior art? Is the inventive step there? Is it usable in it at that end? And find all around the world prior art. As you mentioned before, Rolf, I think you said the European Patent Office does a very good work. I fully agree to this. They have a very broad range of looking for prior art. The point is, do the examiners get enough time to grant us patent which they really are convinced that they are valid, and where they have searched for all possible prior art? And this is what we're aiming for. And that's what quality is for us. That it is, we can, just imagine I put a patent in my portfolio, and then there's prior art around, and it could be easily found. And I think that's what we are filing, what we are paying for with our payments, and that's what I need in the portfolio, and that's where quality comes. Then other quality is it broad enough in the claims, but also not too broad, but also that it really reads on potential competitor products, because we are doing licensing in Ericsson.
So you mentioned licensing. That is one of your income streams at Ericsson, and that probably makes it different from some competitors. How does that influence your IP strategy? Do you have a different filing strategy than competitors? Can you see that the licensing business of Ericsson makes it different?
Very interesting question, Rolf. Happy to answer. Let me share with you that Ericsson is quite active in the development of new telecommunication standards. And in this area, we invest heavily. For example, as today, we are already investing in 6G already for a while. What 6G is going to be, we learn. So investments is there. Then in a few years, the standardization allows any company to use this technology and build on it their own whatever products, phones, and whatever. And we need this return on invest because we spend all the time in developing the networks, the components, and the stuff there. And this is our licensing income. And as you said, this is an important stream for us in order to be able to reinvest the money now already into 6G and develop the new standards. What does this mean for patenting? Coming back to your question, we are filing cases that are not reading necessarily on our products, but that are reading on technology which might be broadly deployed and used by others. And for us, if we are looking what we should file, of course, we sometimes have cases that we say, are we going to build a product on? But we are filing cases which we think is technology-wise one of the best solutions to solve a problem, to solve a technical problem. But it doesn't matter if we use it. So for us, the filing strategy involves, is there a business case for filing the case? If nobody will implement it, nobody will use it, or infringement is not detectable, why should we file? And we have cases which are perfectly patentable, which we don't file because we say the likelihood of finding an infringement is nearly zero, or the business applicability is very low. And so we have to put a guess on this very early on, and then we file cases. So we file cases that we are very sure, or rather sure, that could be used later on in licensing areas as well. But of course, also we have portfolios that are reading on our products and other areas. That's the majority. Then we have adjacent areas where we are filing cases, and but the strategy really follows, is there a business for this in the future?
Right. Okay. So probably not so very different from, for example, Samsung or other telecommunications companies.
I think there might be similar strategies in the area, like our major competitors might do the same, because this standardization gives the access to everybody. But exactly how they file and where, I think that has to be seen by them.
Yeah, sure. Now let's switch to a different topic, the Unified Patent Court. The UPC is opening the doors in June. Are you prepared?
Of course we are.
Of course.
Yeah. When I was the young patent engineer coming to Ericsson, and even before, we were waiting for the Unified Patent Court, the unitary patent to come, and then there were times in between we thought it's never going to happen. Now it's there. I'm a strong supporter and believer in the system. I think it's good because when what I said before, licensing is for us one of the business streams we are working on, and getting licensing income to go court by court in Europe versus, for example, US and others, is not really the best way going forward. With the unitary patent now coming into place and the unitary patent court covering the 17 countries of the moment, this is clearly going to be much more interesting for us to go with our patents. Having said this, a new court, a new system, unknown things, unknown decisions. We are also a little bit reluctantly looking what's going to happen. At the same time, we will have patents in the unitary patent system. I'm very sure we will also use the unitary patent court system because we think it's a good setup that's planned. There are good judges we saw. I like the idea with the technical judges combined. So it's clearly something. Yes, we are prepared. We've been waiting for so long. Now finally it comes. And at the end, I think it's a good system. It's good for Europe. It's good to have it.
You already mentioned that you will use the system, so you will not opt out all your patents out of the within the sunrise period before the start of the UPC system. Do you opt out most patents, or let's say half, or only a few, or the most important ones, or what is your strategy for opting out? And explain.
We will opt out maybe between 20 and 30%. That's
okay. That's not so much. Yeah.
No, it's not so much. We have discussed this thoroughly, and I think it's good to not opt out that many. We need to support also the system. And at the end, after sunrise period, we will have the unitary patent court system as a basis. So why not use it from day one? So, and we are not afraid of this. And of course, strategies might change in the company, but our current assumption is that maximum 30% are opted out, and that's fine. I mean, put majority in the new system and keep some out and see.
Right. So that also would give you the opportunity to also shape the early legislation and the early case law in the system. Because if you are opting out everything, you cannot really influence the early case law. And as we can see from the European Patent Convention, the EPC, that was really the most important decisions came in the very early years, and I also expect that for the UPC to happen. So I'm very grateful that you are saying this because, yeah, some have different opinions, but some are also very pro UPC, and they will use the system. And I think they will have a big advantage because they can shape the case law in their direction, or have at least the chance to shape the case law in their direction.
That's what we are looking into and what we hope. So I think it is important to test out a system. I heard from a lot of companies that they're more in the waiting phase. We might also decide later on, let's see what's going and then go into it. But we are clearly not afraid of the system. And as you say, it might be good to start shaping the new system.
Right. So the rules of the UPC system have been influenced by many different legislations here in Europe. For example, also the UK, and they are not even part of the system anymore. So what would an ideal team look like for you to litigate patents before the UPC? And what would that be different to the current situation where you probably have most litigation in Germany and some in France and some in Italy and some in UK? How would the team differ?
I think it's not differing that much because when we currently do litigation, we don't take just one country. I mean, you could look at what we did in the past. You might have seen we used France, we used the Netherlands, we used Germany. Yes, we used UK. They're not in anymore. But this didn't work in the past without coordination. What are we doing? What are the advantages in the system? So if you now would go for the unitary patent, we would team up these people instead of saying you take Germany and you take Netherlands. We would say you team up as much as the judges will team up. So as an international company, I think it's not this much of a difference. We will, of course, need to get our experience out of this. But from the teaming up, I think I don't see a big difference, really.
Right. The deadlines are quite tight because you only have three months to reply to a complaint and also file your nullity action, the revocation action. So the team is probably necessary, and that's probably a good approach to just team up all the different experts from the different countries to find a good solution for you. Right.
If I may comment on this, I think the short timelines and having a decision, which they say roughly in a year, is also a big advantage. Because if you want, it's also controversial. We might get litigation against us. We have to all the time have, and then we are also in this fast system. But to get a fast decision is a good thing. Yes, you're right. You have short time limits to do certain things, and I would say, and that's maybe the advantage of a little bit bigger company. You need a little bit bigger team. So maybe let me add to what you said before that yes, we team up people, but we might have more teams in the background to support. If the deadlines are getting short and you have to do it within a short time, you need to team up more. But for a bigger company like us, having more people in the IP department, that's easier possible. I feel a little bit with the smaller companies on this, that this is more tricky, but we would need to have backup people and we could have it. And I can just say in my departments around the world, and especially also Europe, people are very eager. They are happy to be involved in such cases. Offensive or defensive.
Right. And you would probably then have a team for prior art search, one team for case law search, and so on. Right.
Yes.
You would have luxury to be able to do that.
Yeah, it's of course also bigger companies have cost restrictions and on this, but at the same time, I think getting a decision within time makes things more efficient at the end for everybody.
Right. Let's also talk about patent pools that are probably quite interesting and important for you in the standard essential patents. What, in your opinion, are the most important developments in the past years, and what is your current wish list for the future?
I mean, it's maybe not in news. People that would know me that I was quite early thinking that the Avanci patent pool for licensing in the automotive area was a good idea. And if you go back a little bit in time, it's bringing licensors together that have a lot of patents, the big ones, the smaller ones, the NPEs and the active companies. And then it offers a large percentage of SEP patents in a specific area, admittedly, automotive, to license. So I think for me, this is very efficient. And it was a good way of approaching the automotive industry, in my view, for giving them access to to a lot of standard essential patents in the field. So that it still took that long, and only in 2022 a vast majority of licensees came in. That was a little bit to my unhappiness, I should say, that it really took this long, because it was in a way at the beginning worked upon together with automotive companies, saying, why can't you bring licensors together? And then Avanci did. And then it still took years and even litigation for them to finally sign. But I think that was a good development. Having said this, as you pointed it out to the standard essential patents, we are doing bilateral licensing with most of the manufacturers of mobile phones or mobile equipment, and that is the most efficient for us. So only when there is efficiency gains in getting all the licensees together, then the pool makes sense. And Avanci is one. There's others. Syswell has pools that are very efficient, but I think for me the automotive one was one of the most efficient ones.
And the role model probably for other industries as well.
Yeah, let's see. I think that's it has to be seen, but it was a fairly good approach, I would say, and giving also the price, putting the price in public, knowing what the price is. I think that was, which other pools do as well, but that was the first time we did it, and it's not an unknown thing to know what do you pay for. And it was $15 at the beginning, it's $20 now, but I'm not an Avanci employee, but we felt from an Ericsson point of view it's a very efficient way. But let me say one thing to this, because lately there has been some development. It's called LNG, license negotiation groups, for the licensees trying to team up. And I saw and heard that there's an interest specifically from automotive companies doing that. But I think the competition law is not really allowing this, and it's good that it doesn't. I know that some friends in automotive industry still try to propagate it, but in my view, what they want to do is to get licensees together to negotiate with like a pool. But that is, I think, not allowing. If this would be allowed, legally allowed, which I think it isn't, it would bring licensees not to negotiate bilaterally, or it would not bring licensees not to negotiate with a pool in a one-to-one. And I think this would be a big holdout. And I just hope that people understand that to get licensees together is something different than bring licensors together. It's not the same. If you give out the right and say you can access, this is the price, and then you cannot team up with licensees and expect that this is legally okay, because this is just bundling and trying to put the market force to put the prices down. And if this is the ambition, and I'm getting a little bit picky on this, but if and it could be that the ambition is to put these LNGs together to bring the prices down, and I think that's not the right approach.
Let's see if someone brings this to court and then how this is decided. That would be interesting. Right. One other thing I wanted to talk about, the German Federal Court of the German Federal Supreme Court has recently limited, or some say they crippled, the claim for injunction a couple of years ago. And then also the law was changed in Germany, the patent law, the paragraph for injunctions. For the business model of Ericsson, what was that good or bad for you? And do you have sympathy for the car manufacturers that initiated this in Germany?
Let me talk about the fact. Yeah, I mean, some say there was a major change in it, but in my view, it wasn't. It was just clarifying the point of that there should be a proportionality check. That was done before as well. The courts had this and did it, and now it's put in the article, and it says that a proportionality test could be done. But in my view, nothing changed, and I think I'm here in good company with a lot of judges that said, but this is just putting down what was done. So in my view, and I can just share that Ericsson and I personally was very involved in these discussions at that time, how the new article should look like. But in my view, it just made a clarification, and that it could be done, as said, was done before. And at the moment, I mean, the argument could be brought up before, it can be brought up today. But I haven't seen lately decisions that took the proportionality point into so much account. I don't think that's anything changed. There was a change in law. And I would say, fortunately, it didn't limit, and that was the initial ambition, to limit injunctions on more complex products. But I think injunctions is a means to that has to stay in Germany and has to be there and has to be used in Germany. I think injunctions is important and to get. It's not to pressure somebody to take a license, but if you don't have injunctions and very limited damage fees, I think that it will not succeed.
Right.
So I think
the recent decisions they show that the judges still give you injunctions as the claimant.
At the same time, if there is proportionality check done and it is showing that it would be unproportional to do so, then I think it's a valid claim and people can, or companies can make it, and it should be considered. But as said, it was not changed in my view.
Right. A last point that I wanted to talk about is AI, artificial intelligence. So AI is an important topic for you, for Ericsson. Where do you see the case law going for patenting AI? Will it be more or less the continuation of the rules for software, or will it be probably develop in a different direction, making it more easy to get patents for AI? And probably there are also other issues like how do you protect a data model or something that is very complex or not even evident for the people who do the research? How do you tackle this issue with AI, and where do you see it going?
Yeah, AI, of course, as you mentioned, is important for Ericsson as well. We do patent filings in the AI area. What we currently see is that we, of course, get patents granted on AI-related matters, but we get also a lot of non-grants out of this, where we need to see and what are the arguments and maybe appeal the decision on it. It's a little bit tougher, and I just lately saw statistics from not that long time ago that only less than half of the patents are granted that are filed in the area, and that's not the statistics we see from our normal areas. We see that the argument, it's not technical, is coming up quite often. So it's quite challenging to get patents granted there. And on top, what we see is that the US and China grants the cases a little more easily than the European Patent Office does. And what a company like Ericsson would like to have is some harmonization and legal security in it. I don't think it's appropriate that there's different methods done. Different offices can have different methods for sure, but it would harm Europe if there would be less grants on it. And then also what we lately saw, we need to investigate a little bit in this, that we are asked to put in use cases where the technology is in the AI core. And then quite often we just get non-unitary complaints about us and should pay more. So I think it's a challenging area. It is also a trial and error for us to talk with the offices. We are very determined to file appeals on these cases and discuss with the boards of appeal what should be patentable or not. I appreciate not everything can be patentable, you file, but I think we should get a uniform, harmonized way of doing it around the world, ideally, and then also get patents where, for example, the core is really technical, be able to get patents on. It would harm us on the long run, on everybody, if you can't get patents on this, but not on any trivial things.
Okay. That was a really good interview, I think. Our listeners will be very grateful for your insights. And we talked about many different topics, and we were probably barely able to scratch the surface of these topics. But you gave very important insights for our listeners. Especially the interviews with corporate counsel are most popular among our listeners. So I'm very grateful that you have been on the show. Thank you very much.
Thank you, Rolf. It was a pleasure to be here and happy to answer any other questions. If somebody wants to reach out, please do.
Yes, probably we can tell them where they can find you. They can find you on LinkedIn. And is there any other preferred method of contacting you?
I think LinkedIn is great, but be prepared. My name is officially Gabriele, so if you look for Gabi, you might not find it, but Gabriele you're gonna find.
Right. Okay. Thank you very much.
Thank you, Rolf.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.